Hello, everyone. This is Nina Olson, the Executive Director for the Center for Taxpayer Rights, and I am delighted to be with you today. We have a great panel. This is the third panel in our series, Reimagining State Tax Practices and Taxpayer Rights. And this one is on collection, both on enforcement actions that are happening at the state and their authority, and then collection alternatives, what you can do instead of enforced collection, what's available to taxpayers. So there are going to be two panels today, and these folks really have a lot of experience in collection. So I think we're going to hear some really interesting things. Our fourth panel is next Tuesday, the 22nd, and that will be dealing with taxpayer advocates and ombuds and state taxpayer bill of rights, and then also funding for low-income taxpayer clinics at the state level so that they can do representation of taxpayers in state tax matters. So without further ado, before I introduce our moderator, I'm going to turn it over to Anna Gooch, who has been conducting and coordinating our survey of state tax practices. And she's just going to quickly share with you some observations we've got in the collection arena from our, from the survey results we've got so far. So Anna?
Thank you. Okay, you should be able to see my slides. I'm just going to quickly cover some really high level results that we've seen so far in the collection space, and this covers both enforcement and collection alternatives. So you'll only hear from me once today because we have really great panelists and I want to give them as much time as possible. So of the results that we've received so far, we're still, our volunteers are still working hard on these surveys, but what we've seen so far is most states allow refund anticipation loans and refund anticipation checks. Not every state regulates them, and usually in those that do, it's sort of in like a consumer protection context, like it'll fall under sort of an equivalent of like a Fair Debt Collection Practices Act. 7 out of 10 use private debt collection agencies, or I should say they allow them. Whether or not they do and to what extent they do really varies among those states. But as you can see, some states just don't allow them for tax collection at all. And then finally, just to cover some collection alternatives, something that you'll hear about later on today during this workshop in the collection alternatives area, is that a lot of states do have, well, most states do allow offers in compromise. But what that looks like in each state is so different. Some really closely follow the IRS's procedures. Some are, the application is, a page long and basically just asks, why should we, settle your debt? Some use reasonable collection potential, similar to what the IRS does. Some do not. And then in terms of like, why a taxpayer might pursue an offer in compromise, most states allow an equivalent to doubt as to collectability. And I apologize for the, most states do offer doubt as to collectability, but most do not offer any sort of like doubt as to liability or effective tax administration category for offers in compromise. So again, this was just very high level, a few select results that I personally found really interesting. There are so much more, and to hear more about it, I'm going to send it back to Nina, who will introduce our first panel.
Great. So Sarah Lora is going to be our moderator for the first panel. And Sarah is a professor and the clinical professor and the LITC director at Lewis and Clark Law School in Portland, Oregon. And so Sarah, I'm just going to turn it over to you and you can introduce the panel and set it up.
Thanks, Nina. Thanks so much for inviting all of us. This is an issue near and dear to my heart. Today's panel, we are going to focus on examples of state enforcement mechanisms. And I'm really excited about our panelists because they're going to talk from their personal experience about what is actually happening on the ground and kind of looking at ways to protect taxpayer rights. So really exciting panel. And I'm going to introduce our panelists. Our first panelist will be Jaye Calhoun. She is a partner at Kean Miller in New Orleans, Louisiana. She practices tax law as a partner, and she is a former ABA tax section state and local committee chair and a fellow of the American College of Tax Counsel, an adjunct professor of tax at Tulane, Loyola, and LSU law schools, and a frequent presenter on tax topics and contributor to tax publications. We also have Nicholas Berger, a director at Frost Law in Baltimore, Maryland. He helps individuals and businesses with a variety of tax-related matters to find relief through efforts as a tax attorney. These include negotiations with the federal and state government agencies to adjust accounts and settle tax matters, criminal investigations, tax planning, and strategy development. His experience working at the Comptroller of Maryland gives him a distinctive outlook on corporate income tax, individual income tax, sales and use tax, withholding tax, and admissions and amusement tax matters. But there's more. In the community, Nick serves as a member of the Maryland State Bar Association Taxation Law Section and the Anne Arundel Bar Association. In 2022 and 2023, he was recognized, although that's in the future, he was recognized as a Super Lawyers Rising Star for his efforts in tax individuals and businesses. And last but not least, we have as a panelist, Audrey Patten, lecturer on law, Harvard University Law School, Cambridge, Massachusetts. Audrey Patten is the interim director at the Tax Clinic and the Legal Services Center of Harvard Law School, where she directs the Low-Income Taxpayer Clinic and supervises casework by law students. Her tax practice includes litigation before the U.S. Tax Court and in the United States District and Circuit Courts, as well as controversy work before the Internal Revenue Service and the Massachusetts Department of Revenue. So as you can see, we have a star-studded panel of great practitioners. So we're going to start first with Jaye Calhoun to talk a little bit about working in Louisiana.
Hey. Okay. So you guys can hear me, right?
Yes.
Okay, good. All right. So I was really excited when I heard Nina and Anna were going out to figure out how to make the world better for folks who have state tax collection issues or state tax issues, because she did such a wonderful job at the federal level, is continuing to do such a wonderful job. But this is really a different ball game in a lot of ways. The nature of our system, basically the states themselves are sovereigns. Within the states, there are localities that are also sovereign that need to basically fund their operations, and they do this through collection of taxes. So the first thing you have to know if you are dealing with any state tax issues is you got to make sure you got the right taxing authority. So throughout the country, many states have various degrees of centralized collection, but we have different types of taxes. Many states impose net income taxes. A lot of them piggyback off what the federal government does, and those taxes are typically administered by state tax departments. Those state tax departments may also administer and collect sales and use taxes. Infrequently, property taxes. Property taxes are typically local taxes. At the local level, you can have income taxes, you can have sales and use taxes, and you can have property taxes. So Louisiana is probably the poster child for making it as complicated as it can be made. Because like I said, a lot of states have centralized collection in various fashion. We don't. We have a different group. Actually, localities each administer their own property taxes, but we have a different system through which those property taxes go if you don't agree with it. And property taxes in Louisiana, and I believe most other states, are actually in-rem taxes. So if you don't pay your real property taxes, the remedy often is a tax sale, which is not necessarily a direct debt of the individual. It's a debt against the property. And, depending on how complicated the notice provisions or how effective the notice provisions are, you may or may not know that your home has been sold at tax sale for failure to pay taxes. A lot of older people who tend to maybe get forgetful, get caught up in this. That's property taxes. income taxes are generally taxes imposed on individuals or businesses. Sales and use taxes are taxes collected by businesses and very infrequently collected from individuals. Often it's much better, more efficient for a tax collector to go after a business that had an obligation to collect and remit taxes, but didn't. It's like one-stop shopping for all the taxes they didn't collect, as opposed to pursuing individuals. So small businesses get caught up in this a lot. So I have for your edification here, list of the collectors in Louisiana. So if you have a Louisiana problem, you got to figure out what kind of tax you have, and then you can figure out who you have to go to. So we have 63 parishes administering their own state and sales and use taxes, and 64 doing property taxes in different departments. So hopefully that's helpful. So business taxes, right? So collection of business taxes is handled in Louisiana in the Department of Revenue by different functions. So individuals are pursued by one function of the Department of Revenue. Business taxpayers who have collection problems are pursued by a different function. And then they contract out collection more frequently for individuals, but definitely for taxpayers that have unpaid or unremitted taxes. The problem, you don't pay your taxes. There are certain things that happen automatically. If individuals don't pay taxes in an amount greater than $1,000, their driver's license can be revoked. And worse, in Louisiana, their hunting and fishing licenses may be revoked. I was actually surprised at people that, actually were more worried about that sometimes than their driver's license. But, but for businesses, we have, again, the state can pursue a business for unpaid tax. A parish can pursue a business, and the remedies are all over the map. Sometimes it's just lots of letters until people step up and enter into an installment agreement or something like that. But the parishes do this more than the state does. They have the ability to go in and file a lawsuit that requires you to show up within 15 days and put on an entire trial to prove you don't owe the tax, or it becomes final. And quite often they're not uncomfortable with issuing proposed assessments based on what they think you might owe, or just because you didn't file a return. It's not like, hey, do you need to file a return? Please file that return. It's like an assessment to which you have to respond, or it becomes final. So, it's a rather complicated set of options they have. I want to say the state is a lot better about sending notices and giving you an opportunity to protest a tax if you think it's not owed. The parishes tend to shoot first and ask questions later. They will offset your federal tax refund. It usually doesn't happen the other way around, where you owe, I'm sure it could happen, federal taxes, and the state takes that to pay state taxes, but it might happen for later periods. Okay, unpaid parish taxes, again, they can come in, they can haul you in a court, they can serve a cease and desist order. I've seen this well, I haven't actually personally seen this, I've heard of this in the French Quarter during Mardi Gras, when the money starts coming in and you're behind on your sales and use tax remittances. They show up at the bars with the badge and just take collections. So it's feels like a little bit like a Wild West sort of thing. Property taxes, personal property taxes actually are a debt of the individual, but real property taxes are collected through the tax sale process. The problem with the tax sale process here in Louisiana is that you might get a notice for that first year, but you might not get notices for other years. And there's a limited amount of time to go in and pay unpaid taxes before losing rights to your property. And the notice is absolutely inefficient. I have a client right now that was completely unaware that their nonprofit property, which shouldn't have been on the rolls in the first place, was sold at tax sale for 4 years in a row until somebody happened to notice something in the paper, because notice can be put in the paper in certain circumstances. So it's unfortunate. What can you do? You got a tax liability, installment agreements. The state will enter into installment agreements for a very short period of time, like they'll go 1 to 2 years. They say they will only do one. Sometimes you can get them to do 2. They want 20% down payment of the tax due when they do it. We do have an offer in compromise process. I think when we first started talking about this panel, I said, I think it's only doubt as to collectability. In the past, before doubt as to liability was mentioned on the form, I used to just scratch out collectability, right, liability, and sometimes they would take it. I went back and looked at the form for this panel, and it actually says doubt as to collectability, but then it puts as grounds doubt as to liability in a hardship type category. But in my experience, they're not looking at it in terms of what you can pay. That way the IRS does, really kind of looking at, you know, we can't get blood out of the turnip. How much blood can we actually get out of the turnip? Okay, we'll take that. They are looking at it based on how much you owe, which, you know, doesn't always kind of line up perfectly in terms of collection opportunities. But quite often, if your situation is particularly sad, you know, you got medical issues and maybe the hurricane just wiped out everything, which happens down here. Sometimes you can get a little bit of a break. It is unfortunate that a lot of times getting that break depends on figuring out the right person to call. You know, I like sometimes, like, I don't do a tremendous amount of collection work. I, you know, help corporations quite often, but I like when people come in and I know that I can help them by getting them to the right person and getting a good collection result for them. But I don't think that's really fair to everybody, because, you know, everybody should have some ability to get to the right person when they have a problem. So at the parish level, again, you have a different set of folks collecting the taxes. You have different procedures. Some of them are a little better than others at working with you. We do have penalty abatement procedures. You can request a waiver of penalty at both the state and local level, but you have to pay the tax and the interest before you do it. So there's no guarantee. And we do have VDA processes. We have a state VDA process, and then we have a VDA process for sales and use taxes for vendors that have presence in the state. We have a different VDA process for vendors who are outside of the state. That one's brand new. You know, so again, it's making sure you get to the right collector to ask for help. Okay, just a few more notes because I think the big hook is coming. My time's almost up. So we have
about 3 or 4 more minutes.
Okay, good. So we have a 10-year collection statute. It's actually not in a statute. It's a, I shouldn't have called it collection statute. It's a collection position because the secretary views, like, there is no law on it, but the secretary generally views it as a 10-year collection opportunity based on an interpretation of the rules that arguably say it should be 10 years. That is, since it is not statutory, I'm always kind of worried about, and I have actually seen instances in which you're going to the collector and you're saying, hey, the 10 years has run, and they're saying, show me where it says I can only do this for 10 years. You know, that's another instance where if you go up the chain, you might get relief. But knowing to go up the chain when the collection officer is telling you, I have an unlimited amount of time to pursue you until, you know, the end of your days is tricky. So tax liens arise by operation of law. They don't give nearly as much notice as the IRS does. I mean, IRS, you get mail, and then you get a CDP opportunity. In the state, you might get a lot of mail, you might not get a lot of mail. Sometimes your first contact is from an out-of-state collection agency, and they don't want to hear it. You know, they don't want to hear any of your excuses or your problems. They just want your money. Or you get a notice of garnishment at work, but you've gotten no mail in advance of that notice of garnishment. The rules for where they have to send notice, when they have to send notice, pretty much let them pick any address they want to pick. So I've absolutely had situations in which the notices have gone, you know, to an address that was on a return 10 years ago, you know, just strange situations like that. We also have state amnesty programs occasionally and local amnesty programs where you can come in and, you know, pay what you owe for some lesser amount. What I've noticed about the interest is after maybe a couple of years, the interest gets larger than the tax liability and keeps growing. So you can have amounts, you know, really ridiculously large amounts when, you know, if the problem had been addressed early on, it would have been a lot smaller. So that ends up being a problem for taxpayers. Now, can you deal with that when the assessment is final? if the taxpayer is uncontrovertibly correct and the liability is not owed, sometimes you can get them to fix that, but you may not have any official right to do it. So, all right, so how'd I do time-wise? We good?
Perfect. Thanks so
Awesome,
much, Jaye.
right.
I didn't see any questions come through on the chat, but just a reminder, feel free to ask questions. And if you have questions for Jaye, we can make that work.
Perfect. All right, so I'm going to start here. Just a little bit about myself. Can everyone hear me before I keep going too much longer? Okay, just wanted to be safe. All right, so here's a little bit about myself. One thing really of note that I just wanted to point out and why I put this in here is I spent 4 years working for the Comptroller of Maryland. That's what the state of Maryland calls itself, the Treasury Department. It's the Comptroller's office. I worked there in the hearings and appeals section, which I'll talk about a little bit later on. It just gives me some good insider knowledge, so I know how it's done there. I know some things are done on the outside. It's interesting. People think they know how it's done, and it's always a little bit worse than that. It's not as malicious, but there's always a little older in coming up with new technology and new methods. Change takes time, and that's something we can talk about in a little bit as we go through these slides. All right, so starting off, just a list of some of the audits and assessments that can happen from the state of Maryland or the Comptroller's office. The QRDT audits, the questionable returns, those are done against individuals. It's your basic audit, often done on Schedule C taxpayers. The CP 2000 is much like the IRS's version, where you're finding unreported income and you get a notice on that. Those are pretty straightforward for the most part. Pending audit letter is typically how a business audit is handled. It's just an initial inquiry saying, we want to look into your place of business. We have some questions for you. Like to set up a meeting. That's how the ball starts rolling, and it goes from there. The RAR is the revenue agent report, which essentially says they found an error in your reporting of some kind. And they want to dig into it a little more. They have a few questions, or they're asking you to provide additional documentation to show that this is correct after all. Balance due notices, pretty self-explanatory. Essentially, a return was filed with a balance due, just wasn't paid for whatever reason, inability to pay or neglect, whatever it may be. And then a refund denial letter, which I'll dive into a little bit more later, but essentially someone's asking for a refund of some kind and the Comptroller's office says no. One of the very frequent complaints I hear from clients, and I've heard back when I worked in the Comptroller's office, I never received this notice. I had no idea I owed this money. I had no idea that my refund was denied. But of course, everyone always gets the notices when they're coming to the Comptroller's, or going to the taxpayer and saying, "Hey, you owe us this money. Please pay it." Those always have no problem finding the right address. So it's just something that's dealt with constantly. I see it all the time. I still see it. Part of the reason I think that happens is because it's sent via regular mail. There's no certified mailing by the Comptroller's office, which is something that I think should be changed in the near future. But for now, that's still how it's done. All right, the timeline to assess. So how statute of limitations, essentially, there's 3 years to begin an audit on an individual from the due date of the return or the due date the return was filed, whichever is later. There's no statute of limitations if the federal government audited the taxpayer or found an error and the taxpayer failed to notify the state of Maryland of that error. If they do, however, they have 90 days to notify them. There's only 1 year for the Comptroller's office to assess that individual. And of course, if no return was ever filed or if there was fraud, there's no statute of limitations and the Comptroller's office can go back as far as it wants. I've seen them go back, almost always they stop around 10 years, practically speaking, but they have the authority to go back as far as they want. In the very rarest of situations, I have seen them go beyond 10 years, but only a handful of times really ever. On the business end, sales and use tax and admission amusement tax, which is an offshoot. I don't think every state has admissions and amusement tax, but it's an offshoot of sales and use tax for the most, just to be very general about it. Those statute of limitations are 4 years in length. Withholding tax is only 3, much like individuals. But again, if there's fraud or gross negligence, There's no limit. They can typically go back as far as they want, but again, 10 years is often the number that they choose. All right. Post-assessment, a taxpayer's ability to challenge after an assessment has already been done. So after an investigation or audit, tax computation notice is issued. This essentially just shows what the balance due may be. It's a recalculation of the tax due, and it tends to show how that number came to be. It's not as detailed as most practitioners would probably want it to be, but it does show the balance due. It does show some bare bones information, so at least you have an idea of what you're looking at. 30 days later after that, a notice of determination is issued. This is the big notice. It comes with appeal rights. Same with the refund denial letter, comes at this point in time. It also comes with appeal rights, and you have 30 days to file a timely appeal to the hearings and appeals, which is where I used to work. They hear hearings for assessments for balances due, disputes, whatever it may be, and timely refund denials. The burden is always on the taxpayer to disprove any assessment or refund denial. So if you go through the audit process, you think you provide a bunch of documentation, and the auditor says, tough luck, this is what you owe. You got to start from scratch and build up your case again, and show that auditor was incorrect. Provide all your documentation, build your case. It's tough. It's tough for a lot of individuals, especially those without representation. It makes it really hard on them. So, okay. So we're here to collection outside of the appeals process. So one of the things I just briefly wanted to talk about on through appeals, you do have the ability to, this is collecting, technically speaking, you can settle through the Office of Appeals. You can dispute the liability and come to some sort of rescission of the assessment or reduce balance due, and they'll work with you to settle it. And that's through the appeals process. There's no collection action being taken doing this as a hold on your account, so you can work through them to come up with some means of settlement. Now, outside of the appeals process, this is where it gets a little trickier. So this comes with some risk. There's no formal means to settle outside of the hearings and appeals office. There's really no guidelines, or there's no IRM with the comptroller's office. There's no corresponding document to an IRM. Decisions are often dictated by internal policy. There's nothing in writing. And frankly, if you're trying to navigate their website or find some clues in their procedures they put out, it's not going to be super helpful. It's a little bit like the Wild Wild West dealing with the comptroller's office, especially when you're outside of appeals. There's no hold, of course, if you're outside of the appeals process, unless you specifically talk to a manager and get them to put in a hold on the account, which can be done. But again, most people without representation don't think to do something like that. They just they think you're working with them, they're working together, and then next thing you know, collection action takes place, and that could be disaster for a lot of these individuals. So my advice is always be proactive to avoid collection action. Don't sit on it. Yes, cases can get lost, but for the most part, being proactive is the safe move. And again, sometimes even when you are proactive, the account isn't always notated properly. If you're just working with one of the call-in offices, they may not put in the notes in the system, and someone else won't see it. And next thing you know, you're getting a levy notice. So again, you got to be very cautious when you're working with the comptroller's office outside of the appeals process. Here are some of the collection actions, different types of collection actions that they can take. License holds, which I'll dig into a little bit more, but professional licenses, which obviously many individuals need to work, driver's licenses, renewals, and vehicle registration renewals. They don't take away your driver's license or your vehicle registration. They just prevent your ability to renew it. So if someone's license is due to expire in the next 6 months, now's the time to act. If they just got their license renewed and a balance comes, you may not be in as much of a hurry, but I would, again, proactive, because certainly other things can happen, such as garnishment of wages, bank levies, liens, and for businesses, revocation of charters, which prevents them from working and operating. Okay, now digging back into the license holds a little bit more. This usually requires a significant down payment and a payment plan to release the hold. The down payment can range anywhere from 10 to 30% of the balance due, with payment plans limited to 2 to 3 years for individuals. Most of the best deals, in my experience, are based off of who you know. So when you go outside the system, reaching out to contacts, managers that are higher up, other people within the comptroller's office, which fortunately I have a background there, so I know a lot of people, but not everyone is so lucky, especially individuals without representation. You know, they have to go through, they think they're following the rules and they're reaching out to the number on the notice they received, but you know, then they're telling them they have to pay the full 33% to get this down. And for a lot of these individuals, those numbers are just not attainable. So it puts them between a rock and a hard place. Okay. Now, the revocations of charters and business licenses. Businesses can temporarily be closed and unable to legally operate until this is resolved. As I'm sure many of us know, or know whether we want to know or not, a lot of our clients sometimes skirt these rules and still try to operate when they shouldn't be, which poses a whole nother set of problems here. But again, these people are, what are we going to do? What are we going to do? We're going to shut down our business and not work at all, and not make any money. It makes things worse. And as my bills pile up further, or just try to survive. And it really puts them between a rock and a hard place. Much like individuals, when those charters are removed and licenses are put on hold for the business, it requires a significant down payment and a short-term payment plan, more so around 2 years for the businesses. Again, these things can get stretched out, which I'll dig into a little bit as we go. But for the most part, short-term payment plans, significant down payments to get the business up and running legally. Now, how to address some of these issues. As I mentioned, it's good to hire people with familiarity and the background of knowing how this works. But oftentimes that's not the case for low-income taxpayers and people who just don't have the means. So there are a few good pro bono services that I always recommend with the state of Maryland. There's a voluntary legal services and tax clinics. I find them both to be super helpful. I've worked with both entities in the past. It's again, they understand the formula of how it works. It's nice to have someone on your side fighting for you. And I always recommend at least having, if you can't afford, a high-priced attorney or even a medium-priced attorney, at least you utilize one of these pro bono services because they can be very advantageous. Once that person's involved, you can work with the collections department or a private debt collector, a third-party debt collector, and offer a compromise program, which I'll dig into as well. Contacting the comptroller's collections department, as far as that goes, there's distinct departments. So if you have a business liability, you're calling a completely different number than if you have an individual liability. A lot of people have, the IRS will have a civil penalties and trust fund assessments. The comptroller's office does similar. They call them officer assessments for responsible parties for unpaid withholding or sales and use tax. And if you have that and you have an individual income tax liability, you have to resolve both of those completely separately. So you have to set up one payment plan for your income tax liability and a completely separate payment plan for your officer assessment, otherwise, the civil penalty. This is, again, something that they've tried to figure out how to merge these two different issues, but that's something that's still being worked on. The comptroller system, I know, hasn't been updated yet to show the screens since I was there. And when I was there, the most recent update looked like it was from the 1970s, if not earlier. So they are very antiquated in how they do some of their technology. The hope is that they'll be able to see this soon, and you'll be able to set up a payment plan for officer assessments and then individual liabilities jointly in the near future. But again, that's a phrase that I was parroting a decade ago. So we'll see how quickly that may happen. One of the problems here with contacting the collections department is there's a long wait time. It's much like contacting the IRS. Again, you get a different individual who may pick up the phone every time. So, if you call on a Monday, they may tell you we need this information, and then you gather that information and call back on a Thursday, and they're telling you they need something else. So that can be quite difficult for many individuals. I always try to work my way up and work with some managers and other contacts with the comptroller's office. It makes things a little bit easier. But if you don't have those direct contacts, you can always ask for a manager conference and, work your way up the ladder of the phone. It's not an easy thing to do, but that would be my best recommendation other than cold calling every time. So the payment plan options, and this is probably some of the big stuff, 36 months, like I talked about before, or 24 months. If you need longer, you can use the financial forms. Maryland has their own version of the 433A and 433B. They don't have they do not include national standards though. So the numbers are much more based on what you can afford, what your expenses are, and what your income actually is. But there's also a wide range between those numbers as well that you're going to have to support. Payment plans, they'll even go up to 99 months if possible, but you need manager approval for that. There's no collection statute, so the balances never get written off ever with the comptroller's office. They file tax liens, which they now have a new rule. They're limited to 20 years. They will eventually remove the least of tax liens, but that takes 20 years. It is retroactive, but again, it's still 20 years is a long time. It's not the 10-year CSED date. And if the balances still exist and there's no tax liens, they're still out there, technically speaking. It's a lot easier to resolve at that point in time, but it does still exist. You can negotiate with them, abatements, settlements for penalties, interest. They are more willing to negotiate for sure than the federal government, but there's lack of uniformity among deals. So you really have to work with them. You may get a great deal for one individual and the next individual is in a much harder space. Trying to go through this as quickly as possible for you guys. The economic hardship program just opened up, similar to currently not collectible with the IRS. It's a welcome addition. It never existed until the pandemic. So this was one of the bright spots to come out of it. You utilize your financial form to negotiate this non-collectible status. There is an ombudsman's office within the comptroller's office. No taxpayer advocate, but there is an ombudsman who's supposed to help in a similar role, at least put you in the right direction and get you in touch with the right person. Again, private debt collectors, cases often get shifted over to them if there's it's just too much for the comptroller's office to handle by themselves at once. So they shift them off to a third-party debt collector. They often get cold cases. The timeline of what a cold case is may vary, but attempts to collect have to have already been made and they were unsuccessful. Some pros and cons with this. Of course, the third-party debt collector is more willing to accept your proposal, I find, because they just want to show money coming in. But some cons, they're not really able to settle with you. There's no negotiation power. They just kind of accept what you can pay, and that's it. And you keep paying until the balance is done. Okay, offers and compromise. I did want to quickly at least touch on this. This is different from the IRS. There is an eligibility requirement. The most recent assessment has to be at least 2 years old. So you can't, you're not eligible if you just got a new balance due. You have to wait at least 2 years from after that's been assessed. So one of the big issues in this case is bridging the gap to eligibility. There's short-term payment plans we often negotiate with some of our clients just to show they're working with the comptroller's office and trying to get to that eligibility period. You prepare a Form 656, the state's version of it, and the state's version of the 433A and or the 433B. And then the narrative is a key factor I use in these offers. Essentially, you use your sob story there. The state actually listens to the, at least in my experience, listens to, pulling out your heartstrings. It's really your time. I always tell my clients it's time to show all the ways that the world has done you wrong, and just let's list it out there. Let's throw everything out there. I, of course, try to edit it and curtail it a little bit so it stays on point. But the idea is to show, this happened, this happened, this happened, and that's why I wasn't able to pay my taxes on time. That led to this issue, but I'm trying to make amends now, and here's how. And you make your own proposal, you propose the settlement terms. It's not based off of a formula like the IRS's status to collectability may be. The older your liabilities, I think the more likely it is to be accepted, especially because those are heavily interest driven at that point in time. There's a high interest rate with the comptroller's office. So that's a big factor for an offer in compromise. And the state can accept it, they can counter proposal, or they can just flat out deny it, and there's no appeals process at all. Generally speaking, I find that they at least counter your proposal. I don't think they very often flat out deny, but
okay, this has been really great, but we need to move on to Massachusetts. Audrey.
Okay. All right. So again, I'm based at the Low Income Taxpayer Clinic at Harvard Law School here in the Boston area. We operate both an IRS LITC, and we also have a grant from the Massachusetts Department of Revenue's Low Income Taxpayer Program as well. So I'm going to talk about Massachusetts enforcement, but bear in mind, I actually speak as an outsider. I don't work for the Department of Revenue. I'm outside the agency. And so my perspective really comes from representing people who walk into our office, normally first with an IRS issue, which is usually a bigger numerical problem. They might come in with a bigger collections bill or a bigger liability at risk, but also a corollary Massachusetts problem that has to be dealt with. One of the things we're always thinking about, and this is true in any state with income tax, is it can be a Pyrrhic victory if you solve their IRS problem, but they're still holding on to a significant liability with the state. A lot of the policy and practice of the Department of Revenue in Massachusetts and tax enforcement is not necessarily laid out in the statutes that give it the governing power to collect taxes. A lot comes through, reaching out to them, talking to them about their internal practice, policy, and procedure that we learn as we go, as we're representing people. Regulations in Massachusetts are under the Code of Massachusetts Regulations, the CMR, so you always want to look there too before you take any action on something. And they have also something called the Administrative Procedure Rules that governs how the agency works. A little bit more on the lay of the land, Massachusetts does not have a dedicated tax court, so you're dealing directly with the agency most of the time. Like all states, Massachusetts is going to try from the taxpayer's perspective, often more aggressively than the IRS to be able to enforce its revenue collection. And that's mainly because it has more enforcement tools right at its fingertips. I'll touch on more of these things in a little bit, but certainly it can take your driver's license from you. It's, a professional license it can take from you. And it is a little more proactive, I would say, anecdotally, in levying bank accounts and wages. Okay. It's important to know too, in any state, what the collections agency does beyond just the tax collection. That's also something that's different from dealing directly with the IRS, because two things: you want to know which is the proper office within the agency to deal with, and also you want to understand why sometimes taxpayers may come to you confused about what actually is at stake. So in Massachusetts, the Department of Revenue also enforces child support. They do that in two ways, both through seeking reimbursement for the state if somebody is receiving transitional assistance from the state and somebody else should be paying them child support. The DOR will step in to reimburse the state for the transitional assistance it's paying. And they also can do it as sort of a third party that receives orders from the family court. Again, I mention that because sometimes I've had taxpayers confused coming in thinking they have a tax issue when really, their communications from the DOR may have to do with child support. Its main purpose, it also works with municipalities on big picture finance management, but its main purpose is collecting taxes for the Commonwealth. I apologize if I interchange Commonwealth and state. Massachusetts, like several other places, calls itself a Commonwealth. So everything official is the Commonwealth. It collects personal income taxes, sales taxes, business taxes. Massachusetts taxes estate taxes over $1 million. Property taxes are, of course, for municipalities to deal with. With personal income taxes in Massachusetts, it's a flat tax of 5% on generally, and the filing requirement is, I believe this upcoming year is $8,000 for a single person. Again, that's important to know because you will have people that, again, are confused. They might not have an IRS issue because maybe they didn't even have a filing requirement with the IRS, but they did have a filing requirement with the state. As people know who work with clients in these situations, it's very stressful when they start getting enforcement letters or calls or enforcement actions being taken. Again, I often find, and this is a theme throughout, that people will use the term IRS a lot, right? They'll come in and they'll say the IRS went after my bank account, and then I find out it's actually Massachusetts. So that is something to always be aware of, whether you're practicing here or elsewhere. But what I do when I'm evaluating somebody is I look, what's the parallel IRS issue? Is there a parallel IRS issue? So I can figure out not only what the two issues are, but what the different enforcement risks are for the person. Again, because there may be differences in federal and state credits and deductions, someone may not have an IRS issue and then boom, they do have a state issue. A good example of that is Massachusetts taxes retirement contributions up front. The federal government doesn't. That's a common disparity I've seen that's resulted in liabilities or collection actions. Is the client up to speed with filing requirements with the state? Like the IRS, the Massachusetts Department of Revenue is not going to be able to work with you on collections alternatives if you have outstanding tax returns. They don't have any strict rule, but the general rule of thumb is going back about 6 years, just like with the IRS, and make sure they're up to speed. You want to know, has the person received Department of Revenue notices? I'll give a brief overview of what those notices are, but even to us, they can be very confusing. They often come in on the same letterhead. You have to look carefully at how they're labeled. They don't necessarily always have an easy to understand letter number the way the IRS does. And often people are coming to us pretty far down in their notice stream. So we need to be aware of that. Again, we want to know what stage they're at. Obviously, just like in any tax intake, is someone being audited or are they in active collections? I've seen people, again, they've had their IRS issue resolved, and so they're confused about, why do I now have Massachusetts collections? So again, we want to look very carefully at any letters coming in. And again, we would want to know, is this something that there's an opportunity to abate the taxes that are due? Or is there, we in a situation where someone has to seek a collections alternative? And we also would want to know, is there an issue for the problem resolution office? That is something that the Massachusetts does have a taxpayer bill of rights, and it includes the mandate that the state have a problem resolution office for taxpayers. It works very similarly to TAS at the IRS, not to be confused with the Massachusetts TAS, the Taxpayer Advocate Service, which works more on big picture policy issues. The Problem Resolution Office is where you call when you need some red tape cut, you need some help understanding, a client's application for abatement's been stuck and you don't know where it goes next. And you really want to look to see if there is a liability that the IRS has abated, because if there is, and there is some sort of Massachusetts enforcement action, you want to tell them that this underlying liability was abated on the federal taxes. You want to have a copy of the transcript and be able to show them, because often that will result in an abatement of the Massachusetts liability. And of course, you need to execute a power of attorney. Massachusetts has an M2848. I can't say that's exactly similar to the federal 2848. There are some different categories on it, some different requirements for when non-attorneys sign it. So again, as in anywhere, you'd want to look carefully at the forms. What Massachusetts does not have, which can make it difficult to evaluate a client situation, is dedicated wage and income or account transcripts. There is an online portal called Mass Tax Connect that for each individual account, a client can log in and see which years have outstanding liability, but you don't get that long running statement that you can get from the IRS showing all the activity on the account. So that is something to be aware of. We often have to go back to the federal transcripts to try and get some idea of what may be happening on the state side. So there are, I'll briefly go over this because this is about collections, but, Massachusetts has 3 years to assess, and again, it can be a desk audit, which is what most people are coming in with, where they're getting correspondence and they're getting notices. The first would be the notice of intent to assess, saying, we think you left off income on the tax return, and you want to respond to it, and you want to show that that was supposed to be there. You can be represented, and then of course for bigger cases there are field audits. You can be represented by an attorney or anyone else qualified to be on the M2848, and you do have a right to appeal if there is an assessment that is made that you don't agree with. Again, most taxpayers don't know how to do this and don't do it. And of course, if you win the appeal, you get interest back on any refund that may be due. Okay. So skipping over though to collections, and this is where most of my clients are coming in at this stage. They got a notice of intent to assess and they didn't appeal it, or they didn't respond to it, or they didn't win if they did. Then comes the notice of assessment. And that's of course when collections is saying this is what your deficiency is. Again, there's no tax court here, so you don't have a ticket to go to an independent forum, but you do have 30 days to either pay the tax or to appeal it administratively. Clients get very scared by this letter. They think they're going to go to jail. They think their house is going to get seized. They think something terrible is going to happen if 30 days goes by. That's not the case. I mean, it means interest is going to start to accrue. If they don't do anything, again, they'll get a statement of account. It's just a more serious version of the letters. And here we start to get into the nitty-gritty of the actual enforcement options. The state can do 3 kinds of levies, actually. I have them all sort of smushed together here: bank levies, wage levies, but a notice of levy on wages or salary or other income is something that will go out, and then a certain amount of time after that, if you don't respond, you might go to work one day and find out that your wages are being garnished. I've had many people come in after getting a notice of levy on other income, a notice of general levy, where they come in and find out that I went to Bank of America and I couldn't use the ATM. I find out there's a levy on it. So that's a real issue for a lot of people. The state does, I cannot give you data on how frequently it's done. I can only give it anecdotally, but I have seen that much more frequently than I have seen IRS bank levies. And then in some cases, it would do a levy to do a direct seizure and sale of property. That almost never happens with any of my clients. Liens, there is a public lien when you owe tax that will attach, can attach to property. And again, this is the big difference here between Massachusetts and the federal government, is that ability to suspend professional licenses that are given by the state, and to not only to revoke and suspend driver's licenses or learner's permits. I went back before this presentation to check the statute on driver's licenses. There is no statutory minimum amount of tax that you owe before your driver's license is revoked. Again, in practice, it's $10,000 of outstanding liability. You have someone come in with a $10,000 owed to the state. You really want to talk to them about, we got to do something to get this down and start working with the state on a payment plan, because your driver's license is in danger. There's also the possibility to do public disclosures. The rule on that is if you owe more than $25,000 and make no effort to pay for 6 months. Again, at a 5% tax, this one almost, again, I have not seen this with my own clients, but that possibility of public disclosure is out there on like a list on the internet somewhere or something. The big thing is that driver's license. Private collections, the statutes do allow the Department of Revenue to turn over collections to private collectors. For any of you who have ever worked in consumer law, you know that comes with its own range, a big host of issues. The big thing with private collections is you can't trust the information flow just because something is stated in a letter. And I always tell clients that. I used to work in consumer law before I did tax, so I'm very leery of this. You always would want to call, you'd want to cross-check with the Department of Revenue to make sure that the amounts supposedly due that are coming from private collection agencies are correct, and that if any payments are made, they're going where they're supposed to go. And I say that again, not to imply, nefarious activity by the private collectors. A lot of it has to come down to how well our accounts being handled and taken care of. And then for practical collections alternatives, there is a state hardship program, which really is like the federal currently not collectible, and you can have a payment agreement. In fact, that's another thing in the Taxpayer Bill of Rights, that you do have the right to talk to the commissioner about a payment agreement. Doesn't mean you're going to get it, but it's recognized as an alternative. And in our experience, really, if someone is working with the DOR and responding to notices and trying to do some sort of agreement, then the more harsh collections actions are not going to happen, or they can be reversed. I wanted to briefly say a little bit more, though, about the driver's license. I put part of the statute here just to point out that upon receipt of notice from the commissioner, meaning the DOR, the register shall suspend or revoke. So this isn't a discretionary action by the RMV. If that notice comes in from the DOR that someone needs to have their license revoked, they will do it. For poorer clients, this has a public policy question mark, because if you take away someone's ability to get to work or get around, how are they supposed to make more money? Contrary to popular belief, most of the people in Massachusetts do not live near Boston or near public transit. The state is a mix of rural and urban, and people are very car dependent, especially when you get outside the immediate Boston area. And something also to know about this too, when you're representing someone, is that if their license is revoked by the DOR, it's not the DOR that will reinstate it. So there is a real practical barrier here. And I have this with one of my clients where he's actually paid off his liability. He has a certificate of good standing with tax, but he has to now go to the registry of motor vehicles and get them to fix his license, which can have its own range of bureaucratic problems and challenges and time and cost and everything else, particularly for poor clients. He actually lives in a rural area and he keeps putting it off because he can't drive to the RMV, as ridiculous as that sounds. So these are very real. And again, the statute on this doesn't actually state a minimum dollar amount for liability.
So we are out of time, but maybe just briefly, your main takeaways would be great.
Well, this is my wrap up, so we're okay. Again, you want to research liability sooner rather than later, because these again, with enforcement mechanisms at the state level, they can happen quicker and they can have an actual bigger impact on someone's immediate life than their IRS liabilities will, which can kind of hang there for years and years. You want to have that established contact with the Department of Revenue and get someone to work with you. One thing I didn't mention is that a lot of that is done by the phone. There's a phone number that will come with every notice. You want to call that number and talk to somebody. And, you want to figure out too, if the person is at risk for enforcement and what kind, and collection alternatives. I will say one last thing really quick. OIC is not a thing in Massachusetts. There is something called an offer and settlement. It's very, very, very hard to get. It has to be personally approved by the Attorney General's office. The reality is you would be looking at some sort of non-collectible status, and it is a 10-year collection statute. So again, you'd want to work on that sooner rather than later. And finally, make sure your person is up to date with filing, just as you would with the IRS. All right, thank you.
Thanks so much. And Nina has given me a direct message that we can go over into the break to just kind of talk a little bit more about certain issues. One issue that I'm interested in is private debt collectors and how that is playing out in your state. I don't know. I know, Nick, you talked about it a little bit, and Audrey as well. Jaye, is that happening in Louisiana as well? Or are accounts getting sent to private debt collectors, and what does that look like?
Yeah, so they absolutely are. So in my experience, when a client approaches me and they have one of these letters, I have just been going straight to the LDR. Because, dealing with the debt collectors, they don't have the information, and sometimes the liability is not good, and you can talk to them about it. What the state does, which is sort of disconcerting, if you move to the state and you start filing, quite often they will send assessments for prior years as if you should have filed. And so this, I've seen this a few times where people are like, you know, the Department of Revenue is basically saying I should have paid, or worse, they don't even learn about it until the license is revoked and they're trying to figure out why. And so, like I said, the notice does break down in terms of letting people know what's going on. So you can, you know, it's not unusual to have a situation in which they actually don't owe this, and you could prove it if you can get to the right person. And it's a complete waste of time to try that with a private debt collector. So what I've been doing is just going to people that I know to say, hey, look, this is wrong. Can we fix it? And quite often they will. But that's, to Nick's earlier point, a problem for folks who don't know to do this, who are just having to argue with the debt collector about, wait, I wasn't even in the state. You know, I mean, you have sort of having to prove this negative, which can be done, but it's problematic. So, but yeah, there's actually at the parish level, quite a few of them will also contract their independent audit function. So you got a lot of interest out of Texas for some reason pursuing Louisiana taxpayers in both audits and collections. So, but yeah, I like to kind of cut to the source there to get things fixed.
So the idea is to try to get it back with the Department of Revenue as quickly as possible. Is that what you're trying to do, Audrey and Nick, as well?
Yeah, quite often, especially if we're trying to negotiate some sort of deal that's not your usual settlement or usual payment plan, because again, they don't have the same authority to operate as the state of Maryland does, because they don't know the facts, like Jay said, and they just get this number saying, okay, you owe $100,000, let's collect, or whatever that number may be. You know, that's it. Their job is singularly focused on collecting the liability, and that's about it.
Interesting. We have a message in the chat from Karen Ward who says that in Indiana, there's questions as to who can send it back to the Department of Revenue. And she says DOR says they can't request it unless PDC releases it, and vice versa. So I don't know if that's
super annoying, but yeah.
That sounds frustrating. Is that anything that the panelists are seeing in their states as well, that trouble getting it back to the Department of Revenue?
For the most part, I think when we ask, they do it, but you do have to ask. We do face that issue, but I think it's the game of where everyone's saying, "Sure, you take it. I'll be happy to get this off my desk."
In Massachusetts, what are you seeing, Audrey?
Yeah, I don't have a problem, but again, it's because our clinic also has a relationship where we're able to call people at the Collections Bureau and resolve somebody's account directly. Somebody just out in the community getting these notices, the danger is that they would be very confused about who to call. But I am not, and I could be wrong, but I'm not aware of anything that prevents something from moving from a private collections agency back to the DOR.
And see, it may be a problem in Louisiana, but like Audrey said, if you're calling the person who can fix it and you know you're calling the right person, we're having a different experience for our clients or people we're helping, and you know, somebody else might be calling a frontline person who is directing them back to the collection agency, which, you know, is unfortunate.
Yeah. One other issue that comes up in Oregon a lot that I just have a personal interest in asking this question is, our state does not account for reasonable living expenses at all. They only look at actual expenses. So for when my clients are homeless and they don't have housing expenses, they often get stuck with the inability to resolve any collection enforcement. So I'm wondering what that looks like in the panelist states and any of the audience's states. I feel like Oregon is abnormal in that sense, but I'm just curious.
You know, I have an ancillary that maybe you can all answer at the same time, which is when they're levying, you know, in the federal government, there are certain exempt assets, you know, there's the standard deduction, you know, dependency exemptions that are exempt from levy. So you have some amount, like if they're doing a wage levy, some amount of your wages are coming to you, you know, business assets, et cetera. So I'm really interested in, you know, in addition to the reasonable living expenses, when you're actually getting to an enforcement action like a levy, what's built into that to protect the living expenses, or is there nothing?
Arkansas, just looking in the chat, it says Arkansas also uses actual expenses and housing expenses. It's a problem.
I'm not aware of any reductions. You know, to some measure, I think that they view it as a way to get you to come in and deal with it. And so maybe they want to be more draconian. What's interesting to me about this panel is you have folks from different states talking about what's going on in their states. And they really are so state specific. Like all these problems are so state specific. And, you know, the Commerce Clause potentially gives Congress the authority to regulate uniformity or create issues to help folks. And so you guys have a big job ahead of you. Either you got to go out and get 50 states plus localities to do the right thing, or, you know, maybe there's a, you know, well, we say there could be a federal solution. Who knows? That's always been a bit of an uphill battle, but I love that you're trying to help folks around the country.
Yeah, Maryland is similar. There's no hard cap number. I mean, they take what they take, and I think it's the exact same thing. It's to get you to the table. You know, it happens once, and then you're there. You know, most people don't let it happen more than once. And sometimes it's not impossible. It's not easy, but it's not impossible to get some of those funds back afterwards. But again, you have to push the right buttons and know what you're doing. And then as far as the allowable expenses, Maryland uses actuals. However, you know, I've been able to use in certain circumstances, I pointed to the national, the IRS's allowable expenses before in certain circumstances as a minimum. And for the most part, they're willing to accept that and work with you. It just every case is different. That's the biggest takeaway I can give if anyone wants from Maryland. Everything is a little bit different. There's no formality at all. You know, it's case by case. Everything is going to be a new adventure for you.
Yeah, I would echo that there is a certain amount of case by case flexibility when dealing with Massachusetts too. Likewise, levies are really to get somebody working with the DOR again, I have found, but again, while representing someone as opposed to someone being pro se, they're relatively easy to pull back if we can show a hardship. And hardship is actually a much looser category than dealing with the federal government. There isn't a strict financial statement after you pull out. A lot of times it's showing a client's story. You know, my client is living in a homeless shelter, or, you know, they're dependent on disability or something like that. So.
Wonderful. I think we really are out of time at this moment. So we will thank our panelists for today. And thank you, Nina, for inviting us all here.
Well, this is just terrific. And I think, as Jay said, there's just been so much variety, and also the issue of driver's licenses and professional licenses seems like a very significant issue. And I love Jay's point about the Commerce Clause. I have to honestly say, I have not thought about this, but we will throw that on the table and see what we can do. What an interesting thing. We just have to get all our con law professors involved to let us know where we need to go. Okay, so, you know, we're going to start our next panel in 2 minutes, which will be really great. And I'll just remind everybody that next week, we're going to be doing a panel on the Taxpayer Bill of Rights and Taxpayer Ombuds, and also specifically on state funding for low-income taxpayer clinics. And the Harvard Clinic has gotten funding in Massachusetts for the clinic to work on state tax issues. And Keith Fogg, clinical professor emeritus, is going to be on next week's panel to talk about that provision. And I think that will be really helpful. One of our goals there in part of this project is to propose some model state laws about how to go about, getting state funding, establishing taxpayer advocate offices. I think from last week, we really want to do a model law for tax courts in the states, and a few other things that we could then share with the legislatures and the bars of the states so that they might want to advocate.
ABA tax has model legislation, which is actually, and I can hook you up with Gar Allen, who's been promoting around the country.
It'd be really helpful.
Model tax court legislation.
That's great. That's really great. Really helpful. And to Luz's question about what other states get funding, that's what we're going to talk about next week. And that's one of the questions on our state survey, so that we can really, rather than word of mouth, get specific issues. And Bree says the legislature always passes. In Arizona, the legislature always passes a conformity bill to conform with the Internal Revenue Code. If your state has a conformity law, perhaps you can take that angle to get national standards as part of the guidance, and IRS as a part of the application rather than the actual amounts. That's interesting. And Utah, Sherry says that Utah is going to consider LITC funding in state legislature in January. And Sherry, if there's a draft statute out there, we'd love to see it. If you want to email it to us, we'd really like to see it. There's some pointers that we may be able to have. So this is great. So in the meantime, now we're going to move on to our next panel. We've touched on this, we've touched on collection alternatives in this panel. It's kind of hard to talk about, collection enforcement without talking about, as we've seen in this panel, without talking about what went before, namely the audit and the appeals stage, and then what comes after, which is the collection alternatives. But this is the panel where we're really going to take a deeper dive into collection alternatives. So I'll turn this over to John Warren from Massachusetts. We've got a good representation of Massachusetts here today. So John, you want to take it away?
Thanks, Nina. And so we have Professor Caleb Smith, who's no stranger to anyone here. He's a clinical director of the Federal Tax Clinic at the University of Minnesota, and he teaches federal tax procedures. We have Krystal Ibarra Premachandra as director of the Tzedek Legal Services, and she's director of the Tax Law Clinic in California, and Karen Ward, who's director of the Low Income Tax Clinic, is Indiana Legal Services. I think, if I may, I'd like to start with Karen because she has some experience influencing state legislation and making changes. And we'll have Caleb and Krystal follow up with their experiences of working with the Department of Revenue to make change.
So you want me to just dive in?
Yep.
Sure.
Okay.
Go for it, Krystal. Karen.
All right. Is it sharing right?
It is. It looks beautiful.
All right. Well, I'm Karen. I'm the director of the Low Income Taxpayer Clinic at Indiana Legal Services. We're a statewide legal services corporation in Indiana. Okay. So first, just a little bit about Indiana collection procedure. They file state tax warrants. Warrant and lien is kind of used interchangeably. They're filed publicly as a judgment lien in the county circuit court. These judgment liens are reported to, there was some discussion about what's reported to credit reporting agencies. These are reported to credit reporting agencies. It's a lien against all property, real and personal, within the state. And the state statute authorizes the county sheriffs to issue the initial tax warrant notices. These are terrifying to people. There's no standard for what the tax warrant notice has to say. Not all of them say this is not an arrest warrant. So people see a tax warrant notice coming from the county sheriff, and they call us and they're scared they're about to be arrested. We've had some discussion with IDOR about whether or not they can regulate the sheriff's notices. They say they cannot, but it's a difference of opinion. So the effects of the state tax warrants. I heard a lot of people talking about driver's license suspension. Indiana does not do driver's license suspensions. They'll offset your tax refunds. They'll file a lien against your vehicles with the BMV. They'll issue bank levies, bank freezes, which are a little bit different than levies, and wage garnishments. And these are done through, we were talking about private debt collectors. Indiana just uses one private debt collector, United Credit Bureau. And also taxpayers cannot get, like a lot of other states, you cannot get new or renew your professional licenses. So the collection expiration, Indiana has a statute that says they have to, the judgment lien or the tax warrant is good for 10 years from filing, unless they renew it within that 10 years. They almost always renew it. And there's no limit to how many times they can renew it. So I have seen tax debts from 35 years ago, state tax debts. And it is incredibly frustrating because once the debt is there, you know that you're going to have to deal with it at some point. So that brings us to what are the collection alternatives. One way that we challenge tax debt for a lot of our clients is through innocent spouse relief. And that's kind of the only one that's challenging the underlying debt. We can go into that. I'll talk about that in a minute. There's payment plans, there's a financial hardship status, and there's offer and compromise. The state of Indiana has created the Taxpayer Advocate Office. It is a division within, we call it, I call it IDOR. I know there's other Illinois and Iowa, but when I talk about IDOR, it's a division with IDOR that is not independent. It definitely acts very aggressively with the collection on the collection side. We do not see them very often taking positions of advocacy for taxpayers. Rather, they're just trying to resolve the collection issues in favor of IDOR. There was also some talk before, I think some states, I think Massachusetts, somebody had mentioned that Massachusetts does not do offer and compromises.
Massachusetts issues 5 or 6 offer and compromises every year. They're generally offered to very large businesses. The offer must be approved by 2 deputy commissioners. There's only 6 of them in this Commonwealth, and the Office of the Attorney General. So when Massachusetts doesn't do offers, you're not going to get one.
Yeah.
Yeah.
So I guess it exists, but the authority lies with the Attorney General. And in Indiana, there is a statute that specifically authorizes the Taxpayer Advocate Office within IDOR to settle tax debts to the extent granted by the commissioner, but the commissioner has delegated all authority to settle and approve and analyze offer and compromises to the taxpayer advocate office, which it sounds like that's very different than how it is in Massachusetts and maybe some other states.
It is. And has the Indiana Offer and Compromise program evolved over the years?
It absolutely has. Just in the last 5 years, it's a completely different program. 5-8 years ago, we didn't even submit them because they were just never, there was absolutely no way that they were going to be approved in any practical manner. I mean, they would require, 75% of the debt paid. They would maybe only settle 20%, 10-20%, and then do a payment plan for the rest. And it was just completely impractical. And yeah, I'll get to it in a second about how it has evolved, because there's been a lot of different changes. The first one that I had was innocent spouse relief. That has really changed over the past maybe 3 years. Indiana used to, okay, sorry, let me go back. Indiana has a state statute that says that you are not responsible for income taxes attributed to the income of your spouse. So you are only responsible for state income taxes based on your income, even if you filed jointly. So taxpayers who are married can file now it's called a post liability allocation schedule to separate their income, their deductions, and their tax liability, so that they're only held liable for their own tax liability. And it used to be called injured spouse, and everyone was confused about what this meant because it's very different. You can't submit it for refunds. You can only submit it for liability allocation. So we had spoken to the commissioner and the advisory council about how confusing this is for practitioners and taxpayers to have a federal injured spouse and have a state innocent spouse allocation, injured spouse allocation worksheet is what they used to call it. So that is one way that they have changed it. They also now allow you to e-file it. So when you're on the tax preparation software, it's and this is just in the last year. It's a schedule that you can submit with your with e-filing your tax return. Okay. Payment plans have also changed a lot in the last few years. They're still not ideal. They're not as good as the IRS, but they now allow up to 36 months, and you can do longer if you submit a financial hardship application. Prior to 2019, the state required 50% upfront, and no matter how much the debt was, a payment plan was 50% upfront, 12 months to pay the rest. And that was another one where we were just giving examples to the commissioner and IDOR administration about how impractical this is. And then people would just end up going into financial hardship status because they can't make the down payment. So they have updated that, and that is a lot more practical for taxpayers now. Let's see. There is financial hardship status. It's not, I mean, it's helpful in the moment if you're facing a bank levy, but because Indiana doesn't have a collection expiration, it typically is not a long-term solution. It also requires all of the same financial information as an offer and compromise. And so you have to submit all of your documentation of income and expenses and assets, that you would submit for an offer and compromise, and then they'll just put you in a hold status for 12 to 36 months, and you would have to do it again. So that's not a ideal option, and that one has not changed despite the last couple of years of all the other changes. The offer and compromise program, like we were talking about, has really changed over the last couple of years. They now allow national standard amounts. They've completely overhauled the OIC forms, and they now look almost identical to a 433 and a 656. Before, it was this kind of very strange state form that had very detailed questions on it that were kind of unnecessary about credit card debt that they don't really use to analyze. So we've changed the form, or sorry, they have changed the form. They've changed the standard amounts. And then after they made all these changes, they were still rejecting offer and compromises if you showed 0 monthly income or negative monthly income. So again, we showed up at the meetings, we provided stories, we provided examples about how impractical it was. Because if they're showing negative monthly income, the IDOR would say, well, then they can't pay the offer and compromise amount, even if the offer amount was $1 or $5. So they have changed, after some advocacy on our part, they have changed their procedure and will now allow those to go through. But the overall procedure for IDOR OIC analysis and acceptance is really still a mystery to us. We've done FOIA requests for their internal procedures. They say that no written procedure exists. So sometimes we will get counter offers that we are just very confused on how they come up with this amount. So that is still something that we're working on, trying to nail down what exactly their state procedure is for analyzing these OICs. Because when you get an IRS, either rejection or counteroffer, they will explain why and their calculations and their explanation in the letter. IDOR does not do that. They just say, no, this is the amount that we will offer instead. So just kind of an overall of some of the collection changes that we've seen since 2018. The innocent spouse, they've changed the name, they've changed the worksheets. The payment plans, there's more options without down payments. There's still generally only to 36 months, but case by case, they will allow us to go beyond that. And then the offer and compromise, they used to just, I mean, I had never seen one even accepted until about maybe 5 years ago. And they've really changed not only their forms and their allowances, but the offers that they're willing to accept. Another big change that we've noticed is that we had advised them for years about how confusing their notices were, especially their proposed assessments and their computation adjustments, which is kind of like a math error. I was just talking to, I'm sure many of you know Jamie Audrey. I was just talking to her yesterday about how we are finally getting able to challenge proposed assessments at the state level, because before we never got there in time because these notices were so confusing. They didn't explain your right to protest. They didn't, I mean, I still cannot make sense of them. And it was a bunch of legalese, and then kind of in the middle of it where you would have to like really look to see exactly what they were proposing. It wasn't a chart, or it wasn't a clear So we've talked to them about that, and they have made some vast improvements on a lot of their notices. We also talked to them about their procedure for releasing liens, because it was very confusing about, I think it was Jay that was talking about once you get the lien, you still have to go to the BMV or the DMV, the RMV. You still have to go to, in Indiana, you still have to go to the BMV and request that the lien be released from the title, even though it's done within IDOR system. And that process is very logistically confusing, and it was nowhere on their website. And finally, it has step-by-step instructions on if your lien is released, if your tax warrant is satisfied, this is how you get the lien released on your vehicle and you get clear title to it. Yeah. And kind of the ways that we have done, worked with IDOR and proposed changes and kind of, for better words, complain to them about their procedures. For the past 5 years, ILS and formerly the Notre Dame Clinic submitted an annual report to IDOR. They have an annual meeting, and we would submit the report in writing, kind of like the way Taz does to the IRS, and we would show up and present our report at the public meeting. And each year, the last few years, they have been submitting responses. So that has been great. There has been kind of back and forth. IDOR also holds their regional meetings for local practitioners and taxpayers. I don't know that any taxpayers really show up, but you can go and they'll discuss kind of like new things going on at IDOR, and you can ask questions and explain the issues they're having, it's always helpful, I feel like, for us if we have examples, taxpayer examples of like the issues that we're facing. We will redact to the personal information and send it to them and explain whatever issue we're trying to argue. And then they also created an advisory council, which they invited the LITC clinic directors to join. So that has been helpful. And then at the most recent meetings, they went through all the new proposed notices and spent 2 hours with us, letting us pick through line by line the language in the notices. So that has been helpful. So then I said, the squeaky wheel gets the grease. So we're always showing up and complaining. So that's how we've
Karen, this
worked.
is a terrific presentation that is just rich with hope and change.
Oh, good.
And it's fantastic. Massachusetts has an advisory council where Luz Aravallo participates on that, where attendees are invited by the commissioner 3 times a year to meet. So if your state has something similar to this, be sure that low-income tax clinics are participating. And if they don't have it, it's a great outreach suggestion, I think. And you can point to Indiana having an advisory council as an example. And that slide of how you implemented so much change over the last 4 years, 5 years is, I think, helpful to everybody here.
Hey, and I also submitted the annual report to, I think, Dolce, if anybody wants to look at it or use it as a, yeah.
Okay, thank you.
All materials are online on your email where you got the link. There's the link to the page. But all the forms and everything.
I'll ask Krystal if she would like to follow Karen here because there are some California similarities and differences and some frustrations. Are you ready, Krystal?
Yes, thank you.
Okay, go get them.
Good afternoon, everyone, or good morning from the West Coast. I don't have any slides to share, but today I was just going to discuss basically resolution options available to taxpayers when in collections with the Franchise Tax Board. I was also going to touch on innocent spouse relief because there are varying kinds, which I was really surprised to find. And if I have time, I'll talk a little bit about liens and levies. So first, to kick us off, in 2016, the Franchise Tax Board drafted and adopted some regulations in order to provide guidance to their agents for evaluating an individual's ability to pay their tax liability. And the reason why they developed the financial statement requirement criteria is because before they weren't, they were requiring a lot of documentation, a lot of substantiation for anything, for any installment agreement. So when this regulation was adopted, now there's some discretion used on whether or not a taxpayer is required to provide a financial statement in order to enter into an installment agreement or reduce an IA or even modify an existing bank levy or wage garnishment. Because in the state of California, when there's a wage garnishment, once it's in place, it can never be released until the liability is paid in full, but it can be significantly reduced. I mean, in my experience, I've reduced a wage garnishment to like $5 before. So that's the best that we can do because it can never be lifted, regardless of hardship status. So in general, a taxpayer is required to complete a financial statement if the total balance is greater than $25,000 or an IA will not be paid in full within 60 months. The tax liability won't be paid within 60 months. Or if the taxpayer claims that they don't have an ability to pay, financial hardship, if the FTB had seized any sort of assets, they will also have to fill out a financial statement, or if the taxpayer has demonstrated a history of noncompliance. So these collection financial standards consider allowable living expenses necessary to provide for taxpayers and its family's health, welfare, and production of income. The standards are pretty much identical to the IRS. The FTB uses the IRS's national standards and local standards. In fact, the financial form is a 3561C, and on the form it almost looks identical to the 433A or F. And in fact, instead of, you can either fill in your actual expenses or there's a little box that you can check that you're using the IRS national standards. And in fact, and they won't ask any questions either if you're using the national standards, or you don't have to provide substantiation unless your balance is like super high. And in fact, if the taxpayer had submitted an IRS form 433A or 433F within the past, I think it's within the previous 12 months, then the FTB will just accept that form in lieu of the state financial statement. So that brings me to the first kind of resolution option of installment agreements. In California, taxpayers don't have an automatic right to an installment agreement. The FTB has kind of streamlined it a little bit. The application may take up to 90 days to process, and it typically grants up to 3 to 5 years to pay the balance. When the FTB is like reviewing this and deciding whether or not the taxpayer qualifies for the installment agreement, if they decide no, then the taxpayer has 30 days to appeal the IA decision. The IA can be done over the phone or online. But if you happen to have a current installment agreement that you want to reduce, a wage garnishment or a bank levy, then you have to call over the phone. And what this means basically is you call the agent. It's different from the IRS, where you call the IRS, you try to enter it into an installment agreement, and you have to kind of fax over the information to the agent while on the phone because they don't provide you a fax number after. For the franchise tax board, in my experience, you can discuss a potential installment agreement, go over the financial verbally, and then if your balance is above $25,000, then you have to get the form filled out, provide some substantiation, and fax it to that particular agent. They give you their specific their fax number. So you're working with one agent. If you don't fax it over within those 2 weeks, then you get put back into the collections queue and you'll have to like call again before they levy your account. So that's
So
what it's
Krystal, you got the FTB streamlined guidance. Is that published on the internet?
Yes, they have. Well, I say streamlined because I'm using that term, but it's not, you know, it's if it's above, you have to be able to pay it within 60 months.
So, but this is an important point, because what I'm hearing from other people is that there's a mystery, everything's different, there's no formality. In Massachusetts, the Department of Revenue has APs, Administrative Procedures, and it's not quite up to the level of the IRM, but I'll suggest it's similar. And that's important guidance as to how to proceed.
Yes. So to answer then in that particular circumstances, yes. The franchise tax board, I will say their website is extremely helpful. They have everything laid out. They will say, you know, what you qualify for. And the hold times are a little long on the phone, but for the most part, you can get through and they're pretty responsive. It's really easy to follow if you're doing it yourself.
And what are your thoughts about assigning a case to a person through completion? Is that effective?
You mean in the installment agreement situation?
Yeah, yes.
Honestly, yes. I particularly like it because I'm able to put the account on hold and then speak with my taxpayer and get all the information, and I'm working with one agent. So if I need a little bit of more time, you know, usually I get it. I'm able to get, you know, another week or another few days. So I don't have to keep calling the FTB and dealing with random different agents. I have one person assigned, and then they're the ones that just get the information. They preliminary will accept it or not, and they send it off to, I believe it's a board, and then the taxpayer will receive a decision within those 90 days. So I particularly like it. I think it's nice to work with one person for the 2 weeks or 3 even, versus like the IRS, where you have to wait really long time to call. And then if you don't have the documents or they need something, you'll have to call back again because you're just not given a fax number to follow up with.
Thank you. Next, I think I'd like to move on to Caleb, if I can, who has a mixed message. We started off with our best foot here with Indiana. Thanks, Caleb.
Okay, so I'm going to talk about, so hopefully everybody can see my screen. I'm going to talk about really kind of high level, not going into the detail, Minnesota collection options with the big focus on offer and compromise. And I'll talk about a little bit more of why I want to focus on that. But my goal really is to get people thinking of how they might pitch offer and compromise as something that their state might want to take on as a viable option. We had Karen talk before about how in Indiana, offers were just not done frequently by clinicians because they were so rarely accepted in the past. And then through advocacy that changed. I might be mistaken here, but I think there's some legislative side to that. In Minnesota, on my side, as we'll talk about a little bit, we also pretty much never did offers. It's just understood that they weren't accepted. It was this common complaint you hear from a lot of states of you send it in, you don't have great guidance, it's kind of a black box, and the default is no acceptance. We took that on as a project. Basically, I had this idea coming in that for some taxpayers, it was so clearly obvious that the offer should be accepted because there was no best interest of the state not to, that if they didn't accept it, we were planning on litigating. We're going to find some way to do that. That never happened because the state was responsive. And so they fixed some things, but we kind of, I always kind of keep the idea of, you want the hammer there to have people moving, so think about litigation at avenues, but, it's an idea of what I was looking at for if they don't accept this offer, I'm going to push. We have a lot of clients that strictly have Social Security as their only income. The state legally cannot touch it. If they accidentally take the client's bank account, which does happen sometimes, you can trace that to Social Security, the state has to give it back. All the state's doing by keeping this income, this collection period open, and by keeping this account open is really inflating their books artificially for this account receivable that's not, wasting money potentially on trying to collect on somebody they can't. And then if they do collect, having to kick it back. And, best interest of the state, we'll get into that a little bit more, the taxpayer, the resident of the state themselves, presumably should figure into the calculus of what the state cares about. People who can never afford to pay their taxes, who are just getting these letters and are constantly nervous on Social Security disability. Perhaps there's a, public benefit welfare, public welfare, we care about the welfare of our citizens argument for why this should be settled. So that is all kind of bigger picture. I want to talk about Minnesota kind of as a case study. So Minnesota has, if you Google Minnesota Department of Revenue, what are your options if I owe taxes? I just cut and paste parts of their little 2-page fact sheet here. And I highlighted that this sheet explains some of your rights during the collection process. But if you're reading the form, if you're Googling, if you're looking at it, it starts with, this bold question of how can I stop all collection actions? Oh, very helpful. You can stop all collection actions if you pay all the money. And guess what? The state won't continue to collect on you if you no longer owe anything. Full pay. That's always an option. To me, that's not that helpful of one. The next option down, if you just keep reading on the fact sheet, is, well, you can enter a payment plan. There's a $50 payment fee, but otherwise you can enter a payment plan. And generally, in my experience, when clients call the Department of Revenue on their own, and this is actually true of the IRS a lot of times too, they try to push you into a payment plan. State will take really random amounts, in my opinion. $30 a month. Can you do $20 a month? Can you do $10 a month? They won't ask for financial if it's a low enough balance. It's just, can you take this amount? And then let's be good, we'll just let that ride forever. Similarly, actually, to what Indiana does, there's basically a lien that lasts for 10 years and the state can re-up it however many times they want. So theoretically, the state can collect indefinitely. I think they really only do that if the person owes a fair amount of money. You go down one level to the kind of very bottom of what's the last option you have. If you owe money, is financial hardship. If you can't afford to pay the fee, you may apply for financial hardship, meaning you can't provide basic necessities. Very much currently not collectible. The one issue in practice here is it's usually not indefinite. It's usually, we will put you in financial hardship for a year, then you have to re-up, which is just kind of a pain for people. So this is as advertised. This is what I see people's actual preferences are. And this is not just Minnesota, in my opinion. This is across the board. This is what taxpayers want when they owe taxes. They want to settle, requesting a compromise. That is not listed on the Minnesota collection options general list of what are my options. It's not, in my opinion, particularly well advertised. And part of what I want to do today is talk about why that might be. It could honestly just be an oversight. The state has been going through a lot of revamp of its website, and it's just not as, this is again something that I think I've heard over and over again from practitioners. The guidance is not as robust for states. It's also just not as well publicized, I don't think, as it is on the IRS side. So maybe this is all just an oversight. They mean to advertise the offer and compromise option, and they just kind of forgot to put it in the list, but maybe not. And thinking about why maybe states are reluctant to do it, you've got Massachusetts where it's basically impossible. I wanted to kind of brainstorm with people and think about, well, why might states think that, and how might we help come up with arguments of why it's not a bad idea to advertise this, why it might be in everybody's interest. I don't think the IRS, I mean, it's statutory why the offer exists, but it's not really a bad deal with how the IRS does things for reasonable collection potential as an offer. The theory is they're actually getting as much as they otherwise would and not wasting their time. Everybody wins. So I want to kind of think in those terms for how we might advocate for states to kind of take on a stronger offer program. So anyway, most of my clients, they want an offer. If they can't get an offer, they want currently not collectible. If they can't get currently not collectible, they want a payment plan. If they can't get a payment plan, well, then what's left? It's full pay. So really the hierarchy of what my clients want is the exact opposite of what the state, basically puts out there as an option. So one thing that I think is important to keep in mind is the different perspectives whenever you're working on these sorts of advocacy issues, or just anytime you're going up against somebody else. It's important to try to see where they're coming from, because I am seeing purely the angels that are my clients. People that have Social Security disability clearly can't pay, and I'm just thinking to myself, how Minnesota are you not accepting this as such an obvious offer? That your process should be simple, should take it, should be done. Why are you wasting your time on this? But the state is seeing a lot of other things beyond my clients. In fact, so we talked to the state, and the state, some of the people that work on their offer program, this particular graph was sent to me by the Minnesota Department of Revenue Collection Division project lead on basically revamping their offers. What I'd heard from them is, look, your clients, we love your clients, but we get a lot of offers from people that are horrible candidates for it. They have this kind of, I guess they'd say, not realistic view of what reasonable living expenses are. They frequently are in a higher tax bracket. A lot of times they have property in other states that we can't really touch, but we don't want to settle their debts because it just seems unfair to the state. If you've got all this property in Wisconsin or somewhere else, and you're saying, well, I can't settle my Minnesota, I can't afford to pay my Minnesota taxes. So this shows that, except for this big group of no adjusted gross income on file, and I honestly don't have an explanation for why that is. For those who have reported adjusted gross income, you're more likely to file an offer in Minnesota the higher you go up the chain, basically $50,000 to $100,000 being the most likely, which is middle income, generally speaking, not within LITC grant guidelines, although it depends on the family size. And then greater than 100,000 is a pretty sizable chunk. So I think it is important to see why the state has some hesitancy sometimes to streamline offer procedures. You'll see the same thing on the IRS side with offer mills. It is a problem. You look at the offer rejection rates and acceptance rates, and more offers get rejected than accepted. But if you were to talk to every LITC, I would be strongly suspicious. I would bet every LITC has more accepted than rejected offers. I could be wrong, but in my experience, it's more accepted than rejected. But nationally, it's the exact opposite. So I think it's just important, just frame wise, to keep in mind that the state is looking at different things, and this is also actually important why they should hear our perspective, because they might be hearing other lobbying perspectives of paid tax preparers that are dealing with businesses and other higher income people that maybe just kind of have to bite the bullet and pay a little bit of money, and they just might not be great offer candidates. So stateside, who submits offers, little higher income. We never used to really submit them, as I said before, and then we worked with the state, we pushed on some things, and now we do it regularly. And some of the things we pushed on really got to why it is in the state's interest, just as tax administration guidelines go. It's not even just low income taxpayer issues, but just effective tax administration. One of the biggest problems I see on state issues is this concept of horizontal equity. And actually, I think Karen touched on this as well. So horizontal equity, kind of in a nutshell, is the idea that two people similarly situated should get similar outcomes. So if you both make $25,000 from Social Security, similar on pretty much everything else, both your offers should be accepted if they're the same. What you see, Karen said something to the effect of, well, you'll get these weird counter offers, or you'll get offers accepted in Indiana, but you won't really know why. And to me, that's usually an issue of having way too much discretion and not enough published guideline and not enough oversight or review from another entity, usually judicial. And you see that played out very much in Minnesota. I think this is kind of the norm. I have not done a study on this in a past life. I was planning on it, but I just haven't gotten the time. I think a lot, I'm not going to say most, I think a lot of states have a statutory language where they'll accept an offer in compromise if it is in, quote, the best interest of the state or something similar to that. And then that's not well defined thereafter. There might be some definitions of allow for necessary expenses and determining ability to pay, blah, 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 but they don't really define best interest of the state. When you have something that vague, it really, really allows for basically the agency to do whatever they want to determine what the best interests of the state are. And again, you get into this published guidance issue. Karen said that there was none published, that they didn't have some for India. That to me is nuts. We did a FOIA request for state of Minnesota on their guidelines, and they gave us some. I didn't think they were particularly useful. It's just kind of like a list of factors that they don't tell you how they weigh. Oh, why is the taxpayer asking for their taxes? The reason why they're requesting their taxes be settled is a factor. That doesn't tell me anything. It tells, like, of course that matters, but in what way and what sorts of matter, like what sorts of reasons count. So it's very broad. Very, boundless discretion almost. And in Minnesota, and I think this is common too, there's not an immediately direct avenue for judicial review. We haven't tried this. This is actually something we're considering after having talked a little bit with Sarah Lora, who I think brought something, and Sarah, correct me if I'm wrong about making stuff up, but I think you were considering doing something in state tax court in Oregon. And I think eventually the Department of Revenue in Oregon just conceded it anyway. But there's not this direct way forward that there is in federal tax matters where you have collection due process. When I look up offer reviews on Westlaw for Minnesota, there's no cases directly on point. There's like 2 cases that randomly touch on it, but they don't go into the depth of why it was a good idea for an offer. And then again, the administrative, no detailed published guidance. So that's all bad as far as tax administration goes. You should not want to have a Department of Revenue. If you're the commissioner of the Department of Revenue, you shouldn't want to have horizontal equity issues. You should want to treat everybody fairly. Practitioners and taxpayers have basically the same concerns when you're working with the client. It has been historically very hard for me to counsel somebody whether their best option is making an offer or trying to do currently not collectible, the equivalent, or payment plan. Federal level, I feel like I can advise on that very clearly. We have a great argument. Your reasonable collection potential is 0. We think an offer is your way to go. State, we think that we can show that you have no disposable monthly income, but maybe the state will still say it's in their best interest not to settle. Don't really know. That's shifting a little bit, which I'll talk about, but still, it's very hard to counsel, and that matters because there's actually, in some states, we've had some benefits here. In some states, there's a serious cost to making an offer that does not get accepted. So, I mean, you might think, well, always counsel, try an offer, and if they reject it, well, then you go to the next best option, especially if they're not paying for your services, as an LITC would do. But that's not always true. In Minnesota, 2 of the things that we brought to their attention and eventually had fixed was, well, you have to pay a filing fee. You still have that in Minnesota, but now they actually publicize when it is waived. Before, they didn't say, well, you can ask for it to be waived. You had to kind of be in the know and ask the state, and they would do that. Now they have a little checkbox, just like the federal, that says, look, if your income is under, I think it's 200% of the federal poverty line, you don't have to pay this fee. But absent that's 250%, or excuse me, $250 fee. And then before, and this one was really crazy, we got the state to change it. To submit an offer, you had to have 2 letters of denials requesting loans. So we'd have clients that were unbanked saying, why do I have to go do this? I'm going to go ask for a loan. I'm going to get rejected. And by doing that, my credit score is going to get hammered. Why do I have to do this? We said, I don't know. The state asks us to do it. We called the state and said, do we really have to do that? And they're like, I don't know. It's not like a statutory requirement. So we brought that to the state's attention, said, look, let's just get rid of this as a requirement. And they said, sure. They got rid of it. They were responsive. The argument that I've been trying to make, so to kind of go back to that, the state has been much more responsive to me. And I think this is where people have inroads. it's easier to get a hold of people in the state that can make changes than it is on the IRS, in my experience. I think it's a little more nimble in that way too. So the state got rid of these two things that we really thought were issues: the unclear guidance on the filing fee waiver and the required loan denial. So those are two things that I take as big wins, but there's a lot more work to be done. The biggest work has to be done on defining this best interests of the state. And this is where I think nationally we have a lot to do. And again, you'd have to look at your own statute to see what it says, but I've done this in Oregon, Massachusetts, and Minnesota. Massachusetts, again, we didn't really do any offers, but best interests was frequently, I've come across this term before. I don't think it's Minnesota specific. What we have proposed to the state and what we're continuing to propose is you can have specific things that you in regulatory guidance consider the best interests of the state. One of those would use the IRS, the federal government model, what works there, use that. So Jaye, Calhoun, before the beginning of this and in the previous one, talked about, kind of a federal solution needed to a lot of these issues. And I think about it sometimes in terms of, well, states are, in the laboratories of democracy. We're supposed to come up with what works on the state and then go up to the Fed. In this case, I think it should kind of be the other way around. What works at the federal level, let's bring that to the states. And what I see working at the federal level, generally, not always, but pretty well done, is if you can prove reasonable collection potential is less than what you offer, IRS accepted. That's doubted collectability. Now, most states, I think with the exception of New York, and there might be a few others, don't really have a doubted collectability criteria, but they still could adopt it pretty easily. It's in the best interest of the state to accept an offer that offers more than we could reasonably expect to collect. That seems pretty fundamentally like it makes sense. And it provides clarity. It gives you as the taxpayer and practitioner a chance to say, well, this is a good potential of acceptance of an offer. We think this is in the best interest of the state. But there's other things you'd want to bring up, I think, to the departments of revenue and the state commissioners and all those other, interested parties for why you would want to argue that this is in this, why the state would want to adopt something like this that's a little more clear. I already touched on a few of them, but I want to hit on them again. There's not a huge benefit. I think one of the reasons states are so loath to advertise offers and to grant them in some cases is this idea that people are getting away with things and we're missing out on money. That's not what's happening with people when the reasonable collection potential is less than what you're offering. There's little to no financial benefit to the state, purely from a numbers game. Forget about welfare of the individual. Purely as a numbers game, there's no benefit to the state to keep these accounts open. You're just inflating your accounting and making it look like you have more money that might come in than you actually will. That's not helpful. Other way that I think it aligns with best interests of the state, I touch on this, the welfare of residents. The state should care about its residents, doing well, being able to pay for basic expenses, being able to pay for housing, those sorts of things. Reasonable collection potential generally aligns with that, because the idea being that if you aren't able to pay, if you are basically, if you have hardship, it means you can't pay for things that we consider basic necessities. The other kind of final point on another state interest, I've just put up 3 potential bullet points, but there's a lot of other ones you could come up with. Reduced administrative costs. There's no benefit to the state just keeping this open and sending out letters over and over again and going after the person if they're not actually going to bring the money in. So I'm going to close with just talking a little bit further about what we did and how maybe that can be a model for other people. We don't have, or at least I'm not aware of, like a meet with all the commissioners, practitioners event. There's a Minnesota State Bar Association tax section that does have like a report from the commissioner and tax practitioners going and all that, but it's not, I don't think, as robust as what I was hearing from Indiana. But we have at the University of Minnesota Law School reached out to some of the commissioners and they were very responsive in setting up basically meetings with our students where we'd say, here's what we see as an issue. We are happy to hear from you guys as to why maybe we aren't seeing the full picture and have a discussion about it. But they've made themselves available to talk about what the issues are. And it didn't just kind of come from, I had a phone call. we sent in a FOIA request, so it's the state equivalent, Private Data Collection Something Rather Act. But we sent in a request saying, we think, well, send us your guidelines for how you evaluate authors. And then the subtext was, we don't think you're following the statute because the statute says you have to have published guidelines. So like one of our requests in the FOIA was, send us the published guidelines. And if they're not publicly available, explain to us why you think published guidelines are fine if it's just published internally with the Department of Revenue. When we sent that in, we got response pretty quickly from not just their disclosure officer, but somebody who works in their offer program saying, hey, can we have more conversation about some of these things? So it led to this ongoing relationship where now we have biannual, so twice a year meetings with the Department of Revenue on these sorts of things. And it's been, again, I think that's kind of the inroad that clinics have is on state issues. You can get frequently to people who can make these administrative changes a lot easier than you can on the IRS level. And I think I've talked way past my time, so I'm going to stop because I think we still have another speaker.
Caleb, I think something that's really interesting to sort of weigh in here. When I was the National Taxpayer Advocate in 2005, got the offer program, which was really struggling. It was not, by at that point, a very good program. Well, the first thing is in 2001, when the offer program was really expanded in the Restructuring Act legislation, the consultants that came in for the IRS took a look at the collectability curve of IRS tax debts, which has normally a CSED of a collection statute of 10 years. And unless you file a lien, yada, yada, you reduce a lien to judgment, et cetera. And they found that after 2 years, collection went pretty much to zero. And we've published that collection curve. And I think in 2018, the Taxpayer Advocate Service in our annual report updated the collection curve to see where is it. And it still is that, after 2 years, the collectability of a debt just drops. And so the consultant said, any debt under 2 years, you should really consider automatically accepting an offer in compromise because it's more than what you would get anyway. Mm-hmm. And then what that led to was 2005, the IRS offer unit did a study of the rejected and returned offers to see where you actually had a dollar amount on the table and then looked at in the years going forward, how much money was collected on that debt that you actually had somebody engaging with you saying, I will pay you this much. And we said no, the IRS said no. And we found, that study's there from 2005, and it showed that the IRS left so much money on the table with individual taxpayers and particularly businesses, because then they were gone. They were out of business and they didn't have responsible persons to collect money against, things like that. And then TAS in, I think it was 17 and 18 annual reports to Congress, we updated that study. And what we looked at was first 1 year, we looked at individual offers that had been rejected or returned. And then we looked at business offers, and particularly with business offers. And then also with the individuals who were usually middle class or even slightly affluent individuals, but definitely with businesses. What we saw in many of those cases was the IRS had overestimated the reasonable collection potential, that there was just, the figures were so out of line with what was actually, the ability to collect in real terms after you'd rejected the offer. And our recommendations were, folks, you really need to look at what it was like great to have as standards, but how you're applying those standards, particularly for middle class and for businesses, including small businesses, really was out of line. And I don't think I've seen any action on that. But I think that data is very interesting. And to the point, Jennifer asked, how did you get this collection data? Did you get that as a result of your FOIA or as a result of the conversations that happened after your FOIA?
As a result of the conversations after the FOIA, so we didn't actually ask for that in the FOIA, and then we had ongoing conversations, and then we did specifically ask for that, but not through FOIA, and they were just happy to give it to us. But the point you made on the collection curve was actually a bullet point I forgot to highlight, but it is a really important one because the common sense is, oh, keep a debt open, we're going to collect more. And I remember Keith Fogg talking a little bit about how it used to be a 6-year federal collection statute, they moved it to 10 years, and everybody, the IRS is like, oh crap, we're not actually going to collect anymore in those remaining 4 years, we're just going to look worse at our jobs. And I think that is an important thing to have numbers on, which TAS has done, to show, look, states, you think that by keeping this open or putting people in kind of indefinite hardship, you're protecting yourself to get more money. That's not what's happening. I think that's having the numbers is critical.
This is where I really would use FOIA at the state level or whatever the equivalent is. It is asking for the data. And my approach to FOIA is on the IRS level. I ask for a ton of stuff because I know what information they have and what information they don't have. And some of what I'm asking, I know they're not recording. And so they can say, we don't have any record of it and we don't have to give it to you. But my point about that is, really, you're not recording this thing that would tell you whether you're doing a good job in administering the law. And that might, in fact, prompt them to start recording it, which will then give you the basis to have a conversation. Look at this, you're not collecting on these things. So I think FOIA can be used, even if you feel like, oh, I'm not getting the information. Showing the gap is sometimes as important to bringing about systemic change as actually getting information, which may not be that good, So
Thank you.
we're up on, John, you want to wrap up? We're at 2:15.
I could throw a whole nother hour in here. We talked about the people who really aren't taxpayers, who don't pay their tax. But what about the ones who file returns on time, pay their tax, have a refundable credit, and there's an identification verification challenge, and these refundable credits? We're going to have to save this for another panel.
Yep, that's another panel. That's a real challenging panel.
Yes, it is. So that is something that would be great to address someday. I would like to take in a 60-second plug for voluntary disclosure programs and make sure that everybody investigates what their state has to offer. This is for the non-filers. Massachusetts, it's a tremendous benefit to the non-resident who moved into Massachusetts and has never filed a state tax return before, and the state is not looking after them. They can become current and compliant by filing the last 3 years and then go into an installment agreement. For Massachusetts residents, you never qualify. You need to file the last 7 years, but if you ever filed one state tax return, you don't qualify for the voluntary disclosure program. Thank you, Nina, for letting me throw out that as a alternative to helping people become compliant taxpayers. And panelists, this is terrific. I mean, every state has something to work on. Every state has good stuff going on. And I think if I had a summary, it's just communications, working with your Department of Revenues and wearing them down.
I really think that what the second shown is the importance of engaging with the tax agency and raising issues. And as Karen said, also giving examples. And I think that's where the clinics are really helpful because, you have such strong examples of the impact of these rules. And it sometimes makes the tax agencies, prior to having clinic representation, they never saw these issues in a systemic or a systematic way. And so presenting that information to the agencies gives them the opportunity to actually, go, oh my gosh, okay, now we have to look at this. So I want to thank everybody for being on this call. It's just a great program. We will get the video up shortly. I've put the link to the materials page in the chat, but it's also in your Zoom notification. And next week will be our final session, and it will be all about taxpayer advocates, taxpayer rights, LITCs and LITC funding. And then we'll get to hard work working on all these recommendations, what we're seeing. Thank you so much, everybody, for attending, and for the panelists and for John and Sarah as moderators. You've done a great job. Lots of really good information, and we'll see you next week. Bye.